So just to introduce myself, as you can see, my name is Suzanne Gower. I work here at the University of Manchester. I lecture in criminal evidence and miscarriages of justice. But before I did this, I was a criminal defence solicitor for most of my career, doing sort of general criminal defence work. And then towards the end of my time in practice, I specialised in appeal cases and miscarriage of justice cases. I used to run the legal charity Appeal, where we just specialised in miscarriage of justice work. I came here to Manchester to embark on my own study, to do a PhD, still in progress. But I was particularly interested in the area, an area of wrongful convictions, looking at people who've been accused of historic allegations of sexual offences. When I was working at Appeal, I would say at least 75% of the inquiries we received from people who said, I've been wrongly convicted, I've been wrongly accused, were of people saying, I've been accused of having committed a crime, a historic offence, often 30, 40, 50 years ago. And it troubled me hugely that there was such an incredible growth in this area of allegations, and that we were unable to assist them in the way we were other people. If people generally came to us and said, I've been wrongly convicted, can you help? Then the basic steps that we would take in their case were often unavailable to people who were accused of historic offences. So I wanted to look at this in more depth, which is what I've been doing. So I'm going to speak to you briefly today about my particular research on this area. I understand that most people here, are not specialists in wrongful convictions and miscarriages of justice. So I want to just use this time just to explain to you, by looking at a different area, the similarities that occur in different types of wrongful conviction and the general flaws in the system that we're faced with. So does this work? So this is my PhD. This is what I'm looking at. It's an empirical study of cases where a wrongful allegation of historical sexual abuse has been made and people have had some contact with the criminal justice system. So some of the people in my study were just asked to come to the police station for an interview, and that was the end of the matter. Nothing else happened. Others have spent many years in prison as a result of a wrongful conviction. So I want to talk to you today primarily about two of the case studies. They've been anonymised, but I've selected two of the research participants, and I want to use their cases as an example to you of what can go wrong in the system, so you can see many of the issues you're looking at today are not just from one case, but they really are quite systemic. So this participant, who I've named John, he was arrested in relation to allegations that were said to have happened some 40 years ago. So he was an elderly man. The police turned up at his front door and arrested him. They didn't give him the opportunity to attend as a volunteer, which means you can say to the police, I'll come down on Thursday afternoon and I will agree to be interviewed. He should have been given that opportunity under the Police and Criminal Evidence Act, which sets out how police should behave in this situation. They denied him that opportunity. He had no knowledge of the criminal justice system, and when he gets to the police station, they said, would you like a solicitor? He said, no, I don't need a solicitor, I've done nothing wrong. And that is something we hear time and time again in this type of case. So he was interviewed without having a solicitor. They later released him and then re-interviewed him again in future, and by that time he did have a solicitor because the people around him had said, go and speak to a lawyer, you need a lawyer here. So he was later interviewed in the presence of a solicitor. He answered all questions that were put to him and tried his very best to put forward an account to what was being asked of him. As I say, these allegations that were being made were things that were meant to have happened some 40 years ago. So I describe here that the police interview is being used as a memory test. One of the real problems in his case that led to his wrongful conviction were that when he was answering the police questions, he made some factual errors. And again, 40 years ago, he was asked what time he had moved to a particular address, and he was out by 2 or 3 years. The police said, you were living there on this date, and he said, yes, we were. He then goes home and says to his wife, they said that I was living there then, and his wife says, no, we weren't married. You were still married to your previous wife. You were living in that part of London. I was living in that part of London. And completely random other people were living in the address in question. So when he's re-interviewed by the police in future, he says, I was wrong on that year. I've gone home and I know I was wrong. I've got my marriage certificate. I've got electoral registers. I know I was wrong. But by then it doesn't matter, because he's given one account in interview and he gives another account, and that makes him out to be a liar, according to the way the evidence is presented. So despite the fact that the weight of the evidence clearly contradicted the prosecution in relation to the date, it was presented to the jury as he was somebody who was untruthful on this key issue in the case. He was legally aided, and he had a barrister who he describes as being useless. He arrived for the first day of his trial and was told that the barrister he'd met with previously and he was expecting to represent him wasn't available because they had a different case that hadn't finished on time. And so his solicitor had found somebody else to represent him, someone he'd never met before, and he was deeply unhappy with what happened. This barrister had the papers for the weekend, doesn't speak to him beforehand, literally just marches into the courtroom to represent him. Now, something that I think will be, will come out as a similarity from the cases that you've been looking at is that the complainant in this case gave 3 different statements over a long period of time, and their account changed in each one of them. And when they gave evidence at trial, it was a different account yet again. And then at his first appeal, the complainant gave evidence again and came up with an entirely different account yet again. So in this case, the appeal was successful, but he was then ordered to be retried. And they amended the indictment at that stage to fit the new account that had gone through all these different variations. But one of the key issues in his case that he found so frustrating was a lot of the allegations that were initially made by the complainant were completely outlandish and highly disprovable. So they were dropped, they were removed from the case. And so he was then denied the opportunity to introduce that as a way of tackling the credibility of the complainant. That was all kept from the jury at his trial. The police didn't pursue any lines of inquiry that came from the witness statements, and where she said that he'd been the centre of a paedophile ring, and she named all these individuals who'd also been involved in it. The police refused to even try to identify them and interview them because they didn't want... The requirement is that the police are meant to look both ways. It's meant to be an independent investigation, but it certainly appeared to John that that's not how it was being done. If the evidence didn't fit the pattern that they wanted it to be fit, then they weren't looking in that direction. And that was how he felt about the investigation. From a defence point of view, he felt that the defence lawyers did no investigative work before the trial. All of the evidence he uncovered to support his account came from his wife, who was the one who was going around the local library and photocopying electoral registers and really getting hold of the medical records from the family and the education records from the family, and really trying to build the case to prove what he'd done. Eventually, when he does get his appeal, many years later, he had a fresh legal team who found a lot more records that were to be introduced, and the Court of Appeal Criminal Division rejected that as fresh evidence, because they said it could have been found earlier. And his point was, well, my lawyer didn't introduce that evidence. My lawyer never looked for it. It wasn't before the jury. The jury didn't know about it. How is it not fresh? But that's not how the Court of Appeal see fresh evidence. They thought the evidence could have been found earlier, and so he was to be punished for the fact that it hadn't been. It took him 8 years to get before the Court of Appeal Criminal Division. He was initially given negative advice from his trial counsel, and he went through 3 separate lawyers, 3 separate legal teams, who all said no, no, until the final team was willing to take it to the Court of Appeal. He was legally aided, which made it even more complicated, because after you've been represented, you have to wait a while before you can get a second opinion, even when that opinion was wrong, which is what ultimately proved to be the case. He succeeded not on any of this fresh evidence, but on a technical legal point that had been missed by each one of the legal teams who'd looked at the case. So the team that eventually succeeded with that, it wasn't fresh in any way, shape or form. It had always been there, but none of the previous lawyers had spotted it. And the really tragic part about his case is that while he was serving those 6 years in prison he served, his wife died of cancer and he wasn't allowed to attend the funeral. His mother died, he wasn't allowed to attend the funeral. And that his case was quashed. He'd already served the sentence by then. They ordered him to be retried, but then they dropped the case because they decided that the complainant wasn't credible at that point. But because the way the case progressed, he never had an apology. He's not entitled to compensation, nothing. They just took those 6 years of his life, and they took that, those last years with his wife were taken away from him. And he says there, why can't these people just admit they're wrong? What stops these people saying, yes, we made a mistake? And maybe if they did that, the court processes and trials would become better. And I couldn't have put it better myself. And then a second research participant who I'll just briefly talk about, again, a historic allegation. It was some 30 years old. Paul felt that there was a policy of believing the victim in this type of offence, which meant that he wasn't treated with any credence or belief, and it was just taken that the other person was telling the truth from the start, and that he was just a fantasist when he tried to defend himself. Again, he criticised the lack of any kind of an investigatory independence from the police, because they had put in subject access requests and data protection requests after the case. They got disclosure of correspondence and emails. And there was a really close relationship between the police who were investigating the case and the people who were making the allegation. So it didn't come across in any way, shape or form as an independent investigation to him. Again, there was a last-minute change of lawyer when someone's case didn't finish, or in this case, someone was involved in an accident. But because Paul was privately paying for his representation, he was allowed to have a say in who took over the case and was far more involved in that process. He also notes that he was actually quite satisfied with the level of representation he received, in contrast with John's case that I've just looked at. He went with someone who's successful, who has a good record, and did a lot of work trying to uncover the details, but he was still convicted. He notes that his legal team made an application for the case to be dismissed. After the prosecution finished their case, he applied for the case to be dropped. And he was told that the judge was satisfied that there were clear inconsistencies in the evidence, but wasn't satisfied that they were so extreme that they would meet the test for this, which meant that no properly directed jury could have safely convicted them on the case. The judge said the complainant so inconsistent and unreliable, but he believed that the jury would see that and didn't want to take away the opportunity for the jury to decide that for themselves, but they didn't. So he really should have said, when it's so obvious it's not valid, he should have thrown the case. But he thought it was so obvious that the jury would see it for themselves. And again, that's a pattern that I think will sound familiar. That the tests that we have in place where we think a case is weak, we put an awful lot of faith in the jury to spot that, and they're not necessarily given the help and what they need to be able to do that. Post-conviction, Paul has spent £350,000 just in legal fees defending himself, and yet hasn't yet successfully overturned the conviction, has served the sentence, but remains convicted. Still with the same legal team, and that they have said that it's not enough. They've been to the Court of Appeal, it was rejected, and his legal advisors have told him that currently they don't think that what they've got is enough for the Criminal Cases Review Commission to re-refer the case. So briefly, just to go through the conclusions from the study and the implications it has, and you can see the wider implications it has in the legal system. There are real issues with legal representation in the system, the availability of it, the quality of it, and the funding that is available for it. The role of the police, going right back to the beginning of these allegations, has to be looked at, and the strategies, particularly when you're looking at historic cases. The lack of investigation that's done by both the police and the defence, which again goes back to the funding issue. Defence lawyers aren't paid to do investigation work, so it doesn't get done. Inadequacy of the trial processes, that the systems we have in place, like the Galbraith test, the half-time test, The system for spotting abuses of process, they're inadequate in many ways. And then finally, questions really have to be asked about the appeal process and the CCRC. When you are dealing with these historic cases, when there is a false allegation that something has happened 30, 40, 50 years ago, you can't find fresh evidence of something not having happened 40 years ago. So the people who are in this type of situation find themselves, absolutely stuck with nowhere to turn. The failure of legal teams to repeatedly spot legal issues when they arise, and John's case is a prime example of that. And the fact that the Court of Appeal have pretty much got rid of what we would call a lurking doubt appeal, where you just look at a case and there's something not right about it. And the incredible reluctance of the Court of Appeal to respond to that kind of case anymore is something that's really come out in my research. So that's it. That was a very quick review of it, and I just wanted to give you an example of the fact that there is, plenty of other areas of the law where there are many similar issues causing problems for people.